Hello, my name is Dr. Sarah Aylward. I'm a senior lecturer in the School of Law at the University of Wollongong. I'd like to begin by acknowledging that I'm recording this paper from the sovereign territory of the Dharawal Nation, land that was never ceded, and I pay my respects to the custodians of this land, past, present, and emerging. I've given my paper a broad title, 18th Century Women's Legal Memoirs, because it's part of a wider research project in which I'm investigating how 18th century women used the emerging genre of the published memoir to reflect on, represent and respond to their experiences of the substance and processes of law. Scholarly accounts tracing the development of 18th century women's life writing emphasise the influence of spiritual life writing, the so-called scandalous memoirs that were widely produced and disseminated from mid-century, and the flourishing of court and society memoirs from the late 18th century and throughout the Regency period. In this paper, I argue that law, legal institutions, and the processes of justice are a further, as yet overlooked influence on the development of women's life writing and subjectivities throughout the 18th century. From mid-century, when Felicity Nussbaum argues women widely produce as well as consume discourses about themselves and their experience, British women appropriated the emerging genre of the published personal account to report, interrogate, and contest their experiences of the law and legal institutions. Many will be familiar with some women who engaged in this practice, particularly women who have rightly or wrongly been labelled scandalous memoirists, such as Teresia Constantia Phillips, Lady Frances Bain, and Letitia Pilkington, writing in the late 1740s and 1750s, and later in the century, actresses including George Anne Bellamy, Mary Robinson, and Leah Sumble Wells. And I believe that there is much more to be said about these texts if they are read through the lens of legal subjectivity rather than of scandal and celebrity. And this is particularly the case as so many of them wrote specifically to contest versions of the self constructed within and authorised as fact by legal institutions and then widely circulated as truth within the newspaper and periodical press. The published memoir offered women an opportunity to discursively construct an alternate self framed through reference to legal norms as well as the emerging conventions of the memoir genre. However, it was not only women who had accrued a degree of fame or infamy who harnessed the power of the published memoir. Several until recently unknown women published works of life writing specifically to address their legal experiences, sometimes, but not always, in conjunction with other activities that were likely to make women infamous or famous at the time, and sometimes focusing only on their experiences of the law. And this trend emerges at around the same time as the scandalous memoirists in the 1750s, and many of these texts have received little or no scholarly attention at all, particularly by Melinda Graham, Sarah Rippon, Dora Tenducci, Anne Bailey, Mary Farrar, and Eliza Frances Robertson. So today my paper is focused on three of these women, Sarah Rippon, Anne Bailey, and Eliza Frances Robertson. Their legal experiences are quite different. Rippon pursued a series of litigations in Chancery. Bailey inhabited most of the summary courts, prisons, and bridewells of London. And Robertson was a notorious alleged swindler who published several memoirs while imprisoned for debt. Yet there are distinct similarities in how they approach the task of writing about their experiences and the discursive rhetorical devices they use to negotiate legal and textual subjectivities. As part of my research into these texts, I'm considering whether the phrase legal memoirs might be useful in referring to these texts collectively as a subgenre of 18th century women's published life writing. In theorising published life writing as a textual expression of women's legal subjectivity, I'm drawing on and applying two approaches to theorising subjectivity. One relating to modes of subjectivity within liberal democracies advanced by Costas Desinas, and the other regarding the relationship between legal subjectivity and cultural phenomena advanced by Peter Goodrich. In The End of Human Rights, Desinas argues that within contemporary liberal democracies, the modern legal subject is split between two forms or modes of subjectivity, and that this division has been developing over centuries. One form of subjectivity is subjectum, that we as legal subjects are constructed to be and think of ourselves as subjects of the law with access to participate in its authorial creation. such as through the franchise, having the legal capability to stand for political representation and work in the legal and political professions. The other form of subjectivity, Dezenus labels subjectus, under the law's authority, whatever form that authority might take across time and place, and obedient to its command under the threat of punishment or other sanctions. Within Dezenus's theory, the modern legal subject of liberal democracies embodies both these forms of legal subjectivity, though the degree to which individuals balance subjectum and subjectus subjectivity will vary greatly based on their access to power and its racial, gendered, class, and other dimensions. By contrast, Peter Goodrich is less concerned with the analysis of legal subjectivity itself than the process by which it is created. This here on the slide is one example of how Goodrich approaches theorising legal subjectivity. He writes, "The subject of legal authority is bound to law far more strongly by identificatory images or phantasms of a shared substance, by interior and self-imposed limitations than by the external dictate of positive law." For Goodrich, law exists not merely in the substance and processes of legal texts and institutions, but much more strongly in the cultural influence it exerts. With respect to subjectivity, then, Goodrich theorises that the authority and power of the law are created through cultural narratives, and that as a result, legal subjectivity, how we understand ourselves in relation to law, is produced through language, law, and cultural discourse. Here I want to briefly outline how I see both these approaches to legal subjectivity might be useful in approaching 18th century women's legal memoirs. Within Dezenus's theory of the split between the subject as subjectus and subjectum, women historically have occupied a status that is far more subjectus than subjectum, placed under the authority of the law, but with few opportunities to participate in its creation or authorisation. Women's legal memoirs then represent resistance to their subjectus status, as they implicitly and often explicitly critique and challenge the law's effects upon them as women, together with the inherent and implicit masculinity of the law. Although legal memoirs do not of themselves enable women to develop subjectum status, they do enable the forging of a new form of legal subjectivity. If, as Goodrich argues, legal subjectivity is produced through law, language, and cultural discourse, the advent of the published memoir as a new use of language and generic form within 18th century cultural discourse empower women to create a new form of legal subjectivity. And this subjectivity was forged directly in response to their experiences of the law and their placement within its structuring of power. Through the legal memoir, women use the confluence of language, genre, and print culture to create a new resistant form of legal subjectivity. To turn now to the three particular women's legal memoirs I would like to discuss, beginning with Sarah Rippon. Sarah Rippon published The True State of the Case of Sarah Rippon in 1756, which was around the same time that women's published life writing became a popular and widely circulated form of print culture, led particularly by Con Phillips and Letitia Pilkington. Sarah Rippon, in contrast to these women, was a middle-class widow who published her memoir after a protracted series of lawsuits triggered by her husband's death to directly and explicitly challenge the injustice she had experienced through the court system. Some background on Rippon. She married John Rippon, a purser in the Navy, in 1732 when she was 18. Before the marriage, John lent money to a naval captain in exchange for a bond and a deed, and around the same time, John also borrowed money from a London merchant. John spent most of the next 12 years at sea with few visits to England. When he was in England, the complexities of his debt and credit transactions increased with respect to both of these parties. And I'm currently in the process of working out just how complex the credit and debt dealings of naval pursers could be. In 1743, the naval captain who was John's debtor died, and in 1746, John also died, leaving Sarah the executrix of his will. So Rippon was essentially a victim of sexually transmitted debt and found herself in two disputes with both John's creditor, the London merchant, and his debtor, the naval captain's heir. The London merchant challenged the will and seized possession of all John's accounts, documents, and legal papers, and Rippon sought and obtained a court order to have them returned. The naval captain's heir refused to honour the bond and deed poll, and Ripon went through no less than 4 cases in Chancery and before the King's Bench over a 9-year period before a perpetual injunction was taken out against her. She was ultimately unable to recover the debt. Now, in relation to Ripon and my other memoirs I'm looking at, I'm going to use paratextual strategies to investigate how each of these women negotiate textual and legal subjectivities in the way that they frame the memoir genre. This provides a point of comparison and contrast between the 3 of them. So Ripon foregrounds her subjectuous legal status, particularly as a widow, in an epigraph from the book of Ecclesiasticus: "Do not the tears run down the widow's cheeks, and is not her cry against him that causeth them to fall." This memoir is Ripon's cry, and the verses that follow speak of God's judgment of all men according to their deeds. Throughout the memoir, Ripon constructs herself unrelentingly as a victim of male enemies who conspire against her and an unjust legal system that enables them. She also writes from a financial motive, not for herself, she claims, but for the fallen mistress and illegitimate children left penniless after the death of the naval captain. It is beyond doubt that Ripon's account of herself, the men with whom her husband had dealings, and the legal system is acutely gendered, and she goes to great lengths to discuss the difficulties and expose the difficulties she faces as a widow in seeking justice. The emerging genre of women's published life writing was establishing new modes of textual self-construction, as well as a receptive audience, which Ripon adopts to name and shame her enemies and to resist the legal system that has caused her such injustice. Her second epigraph states that I have that which passeth all sorrow, the loss of an unblemished reputation. The inclusion of this epigraph is curious, as Ripon does not appear to have been involved in scandal of any kind. She hints at one point in the text of a partnership with one of her lawyers that could give rise to such a suggestion, and she also refers throughout the text to the extent of the general gossip and discussion of her case, though I have found little discussion or even reporting of her cases in the newspaper and periodical press. I am left wondering whether Ripon may have deliberately used the epigraph to lead potential readers to think that in purchasing her memoir, they may have been purchasing a text of the same nature as those published by Phillips, Pilkington and Melinda Graham, but that is speculation. In contrast to Ripon's cultivation of subjectuous legal subjectivity, however, lies the textual reality of the memoir itself, a text that is both self-authored and self-published and widely available across London. She titles the text The True State of the Case, placing it within a juridical framework and staking a claim for its factual accuracy and authenticity. On the first page, she explicitly addresses the public in her foreword, submitting her case to their judgment, where the judgment of judges has failed her. Her disclaimer of her authorial abilities and pretension serves to highlight her claims to the plain factual accuracy of her tale. And throughout the text reveals a detailed and deep knowledge of the legal jurisdictions, of the substance and process of various branches of the law, and a determined capability as a litigant. Indeed, she notes that one of her enemies referred to her as a very good lawyer. Ripon's text then negotiates both textual and legal subjectivities as the emerging genre of the memoir effectively enables the public construction of a new form of legal subjectivity that's been denied Ripon within legal process itself. Turning now to Anne Bailey, who published the Memoirs of Mrs. Anne Bailey in 1771. Bailey was born in 1743. She was orphaned by 7 and entered domestic service at 15. She married James Eastick, a sailor, when she was 17 and was pregnant with her 4th child when he died on a voyage to the Caribbean in 1764. She immediately formed a series of connections with several men, and she was abused, assaulted and entrapped by a range of politically powerful men who she names and shames in this memoir. Indeed, elsewhere, I have spoken of Bailey as perhaps the first #MeToo complainant. Bailey was imprisoned at different times in the Poultry Compter, the Covent Garden Roundhouse, the King's Bench, the Marshalsea and the Borough Prisons, appeared in the Magistrates Court at Bow Street, Middlesex and Higgs Hall, as well as quarter sessions at Lambeth, and she was confined to Tottle Hill Fields and Clerkenwell Bridewells. So between 1764 and 1771, when the memoir was published, and probably beyond, Bailey was trapped in a cycle of debt, arrest, imprisonment, trial and release that was punctuated by numerous episodes of common and sexual assault, from which she found it virtually impossible to escape. So here again are the title page and first page text. One thing that puzzles me about this is how a woman in Bailey's precarious and penniless state gained access to the press or financed its publication. A biographer of one of the men who she alleges sexually assaulted her has suggested that she may have been assisted by the radical John Wilkes, who was her perpetrator's political opponent. The title page indicates that it was printed for the author and offers no information about the printer or bookseller, if a bookseller was involved. And I can trace no print advertisements or public responses to the publication of the memoirs. I consider that perhaps the men she identified may have purchased the entire print run to stop it circulating in public, which is what occurred with Melinda Graham's memoir in 1750. But the title page of the copy from Echo I'm working with is inscribed with the name Redmond Simpson, who was a Covent Garden musician, suggesting that the memoirs were sold and publicly circulated. Simpson, or another owner of this copy, has annotated the text with the names of the men Bailey names. Bailey states her intention to name and shame the perpetrators of violence against her on the front page, and this thread continues throughout the text. Like Rippon, she wrote from a financial motive, and in the appendix to the text reveals that she did unsuccessfully attempt to blackmail John Stewart and Lachlan McLean. However, in targeting these men, Bailey also targets the court and prison system from which she finds it impossible to escape. Unlike Rippon, she does not set out to counter the version of herself that has been crafted through this process or to rail against the judges or jailers she encounters. Indeed, her account is highly detailed but curiously uncritical, as though her experiences were precisely what she would have expected them to be. The textual subjectivity available through the establishment of the life writing genre, nevertheless, enables Bailey to form a new legal subjectivity. Whereas Rippon titles her text The True State of the Case, Bailey uses the specific word memoirs, the genre being well established by the 1770s. Like Rippon, Bailey appeals directly to the candour and good nature of the impartial public, disclaims her authorial abilities, and asserts a commitment to factual accuracy and authenticity. In these respects, she places the text within a juridical framework and also inhabits the subjectus legal status of the defenceless lone mother and widow. Yet the textual reality of the memoirs, and like Rippon, the depth and extent of Bailey's knowledge of jurisdiction, legal substance and judicial process reveal a legal subjectivity that extends beyond subjectus and is enabled by public textual self-construction. My final legal memoirist is Eliza Frances Robertson. Robertson and her companion Charlotte Sharp leased a house in the Paragon, a fashionable Georgian crescent in Blackheath, in May 1800. And Robertson published several works of life writing, and throughout these she claims that she was told that she would inherit a vast sum of money from an ancestral estate in Scotland. And on that basis, she proceeded to represent herself as an heiress and to run up debts of between £15,000 and £20,000 with numerous local merchants and tradesmen for the fit out and the furnishing of this house, which she intended to establish as a school for girls. It isn't clear from the texts whether Robertson had been duped into believing that she was an heiress and then went on to unknowingly dupe her creditors, or whether the entire thing was a sham and that she knowingly deceived them. In December 1800, two of her creditors, Mr. Oakley, a furniture merchant, and Mr. Creasy, a leather courier, began to suspect that Robertson was unable to pay them and unlikely ever to be able to do so. So on hearing this, Robertson and Sharp left for the country. They were traced to Penzance, and they were eventually tracked down, and Robertson was imprisoned for debt in Huntingdon in March 1801. Robertson later relocated to the Fleet Prison, where she died in 1805. So unlike Rippon and Bailey, Robertson's case was highly publicised, particularly in the years 1801 and 1802, and this is largely because of the public anxiety around credit and the fear of swindling. But this publicity in Robertson's case was at least in part fueled by her perceived or actual gender transgressions. She was reported to be a crossdresser, a lesbian and a prostitute, all of which she denies in her autobiographical writings. During her stay in Huntington, her jailer, Mr. Drage, set her up as a public spectacle and charged members of the public to see her in her cell. Accounts of her swindling, her association with Sharp, and her creditors were regularly reported in both metropolitan and regional newspapers and periodicals, and were referenced by Mariah Edgeworth in her essay on Irish bulls. While imprisoned at Huntington, Robertson published 2 works. First was Dividends of Immense Value and My Claim on Others Evidenced by Indisputable Authorities. And the second, Who Are the Swindlers? A Query in 1801. After moving to the Fleet, Robertson published The Life and Memoirs of Miss Robertson, and later a heavily autobiographical novel, Destiny. It's also reported that she published several works on the law's treatment of debtors, though I've been unable to trace them so far. The consolatory verses were published posthumously in 1808. Robertson and her creditors were involved in numerous cases, including litigation between Robertson and her creditors, between her creditors themselves, when one sued the other for giving her a false character in the context of offering her credit. And Robertson also sued those involved in the production, distribution, and sale of her texts for copyright infringement. In contrast to Rippon and Bailey, Robertson presents a much more dynamic relationship between her construction of legal subjectivity with ongoing and emerging legal processes and her creation of alternative textual legal subjectivities in the memoir genre. Her published life writings also display an awareness of the power of the genre and the uses to which it may be put in terms of public textual self-construction that is more sophisticated than Rippon and Bailey. So turning now to Robertson's paratextual strategies. She claims subjectuous legal status in each of her works for different reasons. In Dividends of Immense Value, her target is mainly the press and her creditors who have circulated rumours about her. Apart from her arrest and imprisonment for debt, this work predates her involvement in litigation. It's written as a series of precepts and extracts punctuated by Robertson's legal argument claiming her innocence and presentation of evidence that she is indeed an heiress who will in time be able to pay her creditors. Who Are the Swindlers was written during her involvement in litigation with her creditors, and her choice of epigraph, judge not, yet that ye be not judged, and he that is without sin among you, let him first cast a stone at her, reveals her clear intent to critique the substance and processes of the law through a gendered lens. The text sold rapidly, and in the second edition, Robertson reveals her dynamic responsiveness to her audience. She addresses those who have corresponded with her in a new preface, particularly while she was imprisoned in Huntington, and she writes this new preface to respond to public interest and common queries. This second edition also displays her awareness of how the genre may be utilised and interpreted, and she specifically objects to booksellers who have published and advertised the text as a defence, claiming it is no such thing, but instead a statement of the cruel conduct of others towards her and her friend, the word defence having not only a legal association, but here also an implication of guilt. In the Life and Memoirs, which also went into 2 editions, Robertson's construction of legal subjectivity through the published memoir becomes further dynamic and responsive still. Like her predecessors, Robertson disclaims her authorial abilities and claims a commitment to factual accuracy. Here, her epigraph, exitus acta probat, or the end justifies the deed, speaks to her determination to name and shame everyone she perceives has injured her as justification for her claim to innocence. Unlike her previous works, which were available from booksellers, Robertson also sells her life and memoirs personally from the Fleet as a way of eliciting charitable donations. In the opening pages of this work, she responds directly to questions that have been posed by her correspondents and invites further correspondence as long as those writing her letters pay for their own postage. The Life and Memoirs reveals Robertson's construction of a dynamic and responsive legal subjectivity that is framed within and enabled by print culture. To conclude, the emergence of the published memoir as a popular print genre offered women a new platform to contest their experiences of law and justice. The discursive self-construction offered by the published memoir enabled and influenced the conceptualisation of legal subjectivity beyond subjectuous status, and these memoirs reveal in new ways the discursive creation of legal subjectivity through language, law, and cultural discourse. Collectively, women's legal memoirs function as an interface between women's legal and textual subjectivities, as law's construction of the self prompts not only the autobiographical act, but also the textual construction of subjectivity, both through and in opposition to legal paradigms.